Okay. Estates and land, trying to bang out 10 pages. The beginning of the CMR, real property, page 1, part A. In general, estates and land are possessory interests in land. These interests may be presently possessory, present estates, or they may become possessory in the future estates. They may be freeholds, which give the possession, which give possession under some legal title or right to hold fees or life estates, for example, or they may be non-freeholds, which give mere possession, i.e. leases. Estates in land may be potentially infinite duration, as in the case of a fee simple, or they may be of a limited duration, as in the case of an estate for years. But whatever their characteristics, estate and land must be distinguished from non-possessory interests such as easements, profits, covenants, and servitudes. This section of the outline will examine various estates and land. It divides the interest into two classes, present interests and future interests. However, some future interests, those following defeasible fees, will be considered with the present interests to which they are attached. Present possessory estates, part B. It's after the intro to this section. Your present possessory estates include 1, fee simple absolute. 2, defeasible fees. Well, we're going to get into, in fact, I think I just read this. Maybe not. We're giving it a 3. 3 is the fee tail. 4 is the life estate. Five is an estate for years, periodic estates, estates at will, tenancies at sufferance, which they're calling non-freehold estates, and land, which are considered in the landlord and tenant section, before we get to future interests. And that'll be on page 10. So for the present possessory estates, part 1, fee simple absolute. This is going to be the shortest, sweetest. Get ready for defeasible fees. After that, an estate in fee simple absolute is the largest estate permitted by law. It invests the holder of the fee with full possessory rights now and in the future. The holder can sell it, divide it, or devise it, and if she dies intestate, her heirs will inherit it. The fee simple has an indefinite and potentially infinite duration. The common law rule requiring technical words of inheritance, quoting and his heirs, has been abolished by statute in nearly all jurisdictions. Typically, such statutes provide a fee simple title is presumed to be intended to pass by a grant of real property unless it appears from the grant that a lesser estate was intended. Skipping examples. Defeasible fees, part 2, under present possessory estates. Defeasible fees are fee simple estates of potentially infinite duration that can be terminated by the happening of a specified event. Because defeasible fees can result in forfeitures, courts will construe, where possible, a purported limitation as a mere declaration of the grantor's purpose or motive for making the grant. For example, precatory language. A, under defeasible fees. So what's the court going to construe? A purported limitation as a mere declaration of the grantor's purpose or motive for making the grant, i.e. as precatory language. Okay. A, fee simple determinal and possibility reverter. A fee simple determinal, also called a determinable fee, is an estate that automatically terminates on the happening of a stated event and goes back to the grantor. It must be distinguished from the fee simple subject to a condition subsequent, where the grantor must take affirmative steps to terminate the estate of the grantee if the stated event occurs. It is created by the use So it's not a condition subsequent. Again, this is a fee simple determinable. So I don't know why they just threw it in distinguishable from this. We're talking about a fee simple determinable and possibility of reverter, which vests in the grantor. So it's like its corollary, future interest. It is created by the use of durational adverbial language such as, this is your fee simple determinable, for so long as, while, during, or until. A fee simple determinable can be conveyed by the owner thereof, but his grantee takes the land subject to the termination of the estate by the happening of an event. So your examples in this section which matter are O conveys land to A for so long as no alcoholic beverages are consumed on the premises. This gives A fee simple because the estate may last forever if no one ever quaffs a brew. If A conveys his fee simple determinable estate to B, B will own the for so long as estate. If A does not convey his estate on A's death, it will pass by will or intestacy to his successors, and so on. If, however, someone ever consumes an alcoholic beverage on the premises, the estate will automatically come to an end according to its own terms, and O will immediately and automatically become the owner of the fee simple without taking any steps to terminate A's interest. 1. Correlated future interest in grantor, the possibility of reverter. Because the grantee's estate may end upon the happening of a stated event, there is a possibility that the land may revert back to the grantor. The interest that is left in a grantor who conveys an estate in fee simple determinable is called a possibility of reverter. It is a future interest because it becomes possessory only upon the occurrence of the stated event. A, within this section, possibility reverter need not be expressly retained, and B, transferability of possibility reverter. So at common law and in nearly all states today, the grantor does not have to expressly retain a possibility reverter. It arises automatically in the grantor as a consequence of his conveying a fee simple determinable estate with its built-in time limitation. Transferability of possibility of reverter. At early common law, the possibility of reverter could not be transferred inter vivos or devised by will. An attempted transfer of the interest was invalid, but the possibility of reverter was not distinguished by the attempted transfer and would still descend to the heirs of the owner. Today, in most jurisdictions, the possibility of reverter can be transferred inter vivos or devised by will and descends to the owner's heirs if she dies intestate. That helps to answer like a lot of MBE questions. Correlative future interest in third party, executive interests. Correlative future interest in the third party, executive interest. A possibility of reverter arises only in the grantor, not in a third party. If a comparable interest is created in a third party, it is an executory interest, which we're going to get to after the next section, which is beginning now, the fee simple subject condition subsequent, and the correlative future interest of the right of re-entry. A fee simple subject to a condition subsequent is created when the grantor retains the power to terminate the estate of the grantee upon the happening of a specified event. Upon the happening of the event stated in the conveyance, the estate of the grantee continues until the grantor exercises her power of termination, which is also known as the right of re-entry. Right of entry, by bringing suit or making re-entry. The following words are usually held to create conditions subsequent. The words upon condition that, provided that, but if, and if it happens that. Giving an example, O, owning Blackacre in fee simple, conveys it to A and his heirs on the express condition that the premises are never to be used for A for the sale of liquor, and in the event that they are so used, then O or her heirs may enter and terminate the estate hereby conveyed. A has a fee simple subject to a condition subsequent. O has a right of entry. If the condition is broken, O has a power to terminate the estate of A by asserting her right of entry. I made it actually clear. Correlative future interest in grantor, right of entry. A right of entry, also known as right of reentry or power of termination, is the future interest retained by the transferor who conveys an estate on condition subsequent. It is necessary to expressly reserve the right of entry in the grantor. This retained interest does not automatically arise, as in the case of a fee simple determinable and possibility reverter, which I'm surprised to hear that. Anyway, failure to reserve right of entry. Courts often hold that words of condition standing alone create only covenants, easements, or trusts and are merely precatory terms. Example, O conveys land to A and his heirs, provided that liquor is not sold on the premises. O has not used words indicating the estate will terminate if liquor is sold on the premises, nor has O retained a right to re-enter. Because a statement of the grantor's wishes as to how the property should be used does not ordinarily imply a right retained by the grantor to enforce the purpose, a court may construe the deed as giving a fee simple absolute. And this is a Wyoming case, 1988, Wood versus Board of County Commissioners. Waiver of right of entry. Because the grantor can elect whether or not to terminate the grantee's estate, she may waive her right or power to enforce a forfeiture by express agreement or by her conduct. Such is not the case with a fee simple determinable where the forfeiture is automatic. Inaction by itself, not a waiver. She may waive her right or power to enforce. Yeah, I knew that. By express agreement or by her conduct, which is not the case in the earlier example of the fee simple determinable. So inaction by itself is not a waiver. The general rule is that when there is a breach of the condition and the grantor simply does nothing about it, the power of termination is not waived. However, where there is an element of detrimental reliance by the fee holder, many courts treat inaction as a waiver on an estoppel or laches theory. Okay, so express agreement or conduct in an activity tends not to be that conduct. Transferability of right of entry. At common law, a right of entry was not divisible or transferable inter vivos to a third person. The right of entry did, however, descend to the heirs of the grantor on her death. Today, in most jurisdictions, a right of entry is still not alienable inter vivos. Indeed, in a handful of states, an attempted transfer destroys it. But in most states, rights of entry are divisible, and in all states, they descend to the owner's heirs. Try to remember that because you're going to probably be writing about it. So, right of entry in a handful of states. Well, at common law, it was not divisible or transferable inter vivos or to a third person. So that is still the case in most. No. In a handful of states, an attempted transfer destroys it. But in most states, rights of entry are divisible, which is a complete opposite of what happened in common law. And in all states, they still descend to the owner's heirs. So that is retained in all states. However, it's now divisible in most states, which is the opposite of the common law practice. And however, in a handful of states, an attempt to transfer destroys the right of entry. Correlative future interest in the third party, executory interest. So, okay, so this is still within the fee simple subject to condition subsequent section. So we haven't moved on to the next fee simple subject to executory interest, which is the third crazy grant of a defeasible fee. Correlative future interest in the third party as an executory interest of the fee simple subject to condition subsequent reads. A right of entry can be treated only in favor of the grantor and her heirs. If a similar interest is created in favor of a third party, the interest is called an executory interest. For example, if the property is ever used for other than church purposes, then to be and his heirs. Unlike a right of entry, an executory interest is subject to the rule against perpetuities. So, comparison to the fee simple determinable. This estate is distinguished from a determinable fee in that a breach of the condition does not itself terminate the estate and immediately revest the fee in the grantor or the successor. The estate continues in the grantee or his successors unless or until the grantor or her successor affirmatively elects to terminate it. Construction of ambiguous language. The general policy of courts is to avoid forfeiture of estates. Thus, a conveyance that contains both durational language and a power of termination may be construed as creating a fee simple subject to a condition subsequent because the forfeiture is optional at the grantor's election rather than automatic. Examples here. O conveys land to A so long as liquor is not sold on the premises, and if liquor is sold, O has a right to re-enter. The words so long as point to a fee simple determinable. The retained right of entry points to a fee simple subject to condition subsequent. The court can classify the language to create either state, but the fee simple subject to condition subsequent is preferred rather to avoid because why? Because the courts prefer forfeiture of estates. All right, last defeasible fee here is the fee simple subject to an executory interest. A fee simple subject to an executory interest is an estate that, upon the happening of a stated event, is automatically divested in favor of a third person rather than the grantor. O conveys land to church, provided, however, that if the premises shall ever cease to be used for church purposes, title shall pass to the American Heart Association. Church has a fee simple subject to an executory interest in favor of the Heart Association. O does not have a right of entry because no such interest was reserved in the conveyance. The Heart Association's interest is not a right of entry because the future interest can be reserved only in favor of a grantor. The Heart Association's future interest is not a remainder because it divests a fee simple. Therefore, it is an executory interest. I understand why it's not a remainder, but the Heart Association's interest is not a right of entry because that future interest can only be reserved in favor of the grantor. Okay, we already read. So basically, that was a crazy rule that we read in the last section. Note, executory interests are subject to the rule against perpetuities, but the Heart Association's interest is valid because of the charity-to-charity exception to the rule, which I believe is called Cypress. Don't forget it. O conveys land to church for so long as the premises are used for church purposes, and if they shall ever cease to be so used, then and in that event to the American Red Cross. Church has a fee simple determinable subject to an executory interest in favor of the Red Cross. O has no possibility of reverter because he has not retained any interest. He has conveyed away his entire estate in the property. The future interest in the Red Cross cannot be a possibility of reverter because that interest arises only in the grantor and the Red Cross is a grantee. It is an executory interest and not a remainder because it vests a fee simple. Further discussion of these points will come later. I don't understand how this is different I mean, this one was for church purposes, and if they shall ever cease to be so used, then and in that event to the third party. Whereas this one is upon the happening. This one is shall cease to be used for church purposes. Title shall pass to another group. Is it this? Does it have the same effect? No. Were it not for the charity exception, the rule against perpetuities, the executory interest in favor of the Red Cross would violate the rule. Okay. Whereas the last one wouldn't. I think. I'm kidding. I have no idea. Limitations on possibilities of reverter and rights of entry. In a few states, statutes limit the permissible duration and possibilities of reverter and rights of entry to a certain number of years, usually 30, in order to foster marketability of title. Other statutes, usually called marketable title acts, require the re-recording of various future interests, including possibilities of reverter and rights of entry every 20 to 40 years, or they become unenforceable. Okay. Conditions and limitations violating public policy. Conditions and limitations are designed to prevent the acquisition or retention of an interest in land, generally are struck down if they are contrary to public policy. Striking such a condition will result in an interest different from that intended by the grantor. Restraints on marriage is an example of a condition or limitation violating public policy, as well as provisions involving separation and divorce. So, restraints on marriage. If the purpose of the condition or limitation is to penalize marriage, it likely will be struck down. On the other hand, if the purpose is to give support until marriage, when the new spouse's obligation of support arises, the condition or limitation generally is upheld. And there's examples, and I don't care. Provisions involving separation or divorce. Conditions and limitations meant to encourage separation or divorce are invalid. On the other hand, conditions and limitations meant to give support in the event of separation or divorce generally are valid, which is contradicting the point. Fee, tail, life, estate. All right. And then, okay. So, I'm just going to read fee tail. Life estate gets a little bit long here. A fee tail typically created by the words to A and the heirs of his body, limited inheritance to lineal descendants of the grantee. If no lineal descendants survived at the grantee's death, the property either reverted to the grantor or her successors or passed to a designated remainderman. Today, most United States jurisdictions have abolished the fee tail and have enacted statutes under which any attempt to create a fee tail results in the creation of a fee simple. And then we get to life estate, which is an estate. An estate for life is an estate that is not terminable at any fixed or computable period of time, but cannot last longer than the life or lives of one or more persons. It may arise by operation of law or may be created by an act or agreement of the parties. So life estates by marital right, legal life estates, and conventional life estates are discussed. Within the conventional life estates, you have for life of grantee, life estate for ultra v, life of another, which is inheritable, and rights, or at least has an inheritable section in that section. And then you get to rights and duties of the life tenant, which is to refrain from like affirmative voluntary waste of natural resources. Permissive waste is discussed, and there's no obligation to insure the premises or liability for third-party torts. So the life tenant is under no obligation to insure the premises for the benefit of the remainderman. However, both the life tenant and the remainderman have an insurable interest. No liability for the third party's torts. Unlike a modern view, life tenants are not responsible to remaindermen as they were at common law for damages caused by third-party tortfeasors. The life tenant's action against third parties is limited to the damages to the life estate. Okay. So the life tenant doesn't have to insure the place, and it doesn't even have to protect it from their like guests. But let's look at these dower and cursey. Okay, so the legal life estates, the life estates by marital right, include dower and curtsy, which is the common law interest in the wife and the husband, respectively, in real property of which the other spouse was seized during marriage, including property acquired before marriage, a common law surviving wife's dower right entitled her to a life estate in the undivided 1/3 of the husband's lands. A surviving husband's right of courtesy gave him a life estate in all of his wife's lands. If issue were born for exam purposes, it is important to remember that a conveyance by a husband to a bona fide purchaser does not defeat dower unless the wife joins the conveyance. Likewise, a husband's creditors cannot defeat a wife's dower rights. Most states have abolished both dower and courtesy and have instead given the surviving spouse a statutory right to take a portion of the deceased spouse's estate. Community property states do not recognize either dowry or courtesy. Is it really courtesy? But it's not spelled courtesy. Anyway, I think there's a word for that statutory right. I just can't remember what it is. Conventional life estate, 1. For life of the grantee, the usual life estate is measured by the life of the grantee and is called simply a life estate. It may be indefeasible so that it will end only when the life tenant dies, or it may be made defeasible in the same ways that fee estates can be defeasible, i.e. determinable, subject to conditions subsequent, subject to an executory interest. In such a case, the estate may end before the life tenant dies if the limiting condition occurs. Bunch of examples. I'm not going into them, even though I probably should. Life estate per attribute. Wait, does it also say what it is? Shoot myself. Oh, I'm gonna read these. O conveys to A for life. In this case, A has an estate in the land for as long as he lives. On his death, the land reverts to O, the grantor. That's a fee simple determinable, even though it doesn't say so. I know that. With a possibility of reverter. To A for life, then to B. This is a life estate because it is measured by the life of A and is not terminable at a fixed period of time. So that one's like a fee simple subject to executory interest. I'm surprised I didn't say. 3. To A for life, but in no event for more than 10 years. This is an estate for years and not a life estate because the estate in A will end in 10 years. To A for 10 years, if he lives so long. This is also an estate for years and not a life estate because the estate in A will end in 10 years. It's an estate for years. Only because it doesn't say what happens if they die. It's probably a possibility of reverter because it can't be right to reentry if you don't say it. So it's a fee simple determinable. To A for 10 years, no. To A for life or until she remarries. This is a life estate subject to a limitation, but nevertheless a life estate. The estate in A will not end at any fixed or computable time period and can be termed a life estate determinable and is analogous to the fee simple determinable discussed above. It's also, again, violates public policy, kind of. To B and C after the life of A. A has an implied life estate, okay. And then so for the life of another, it's life estate per autre vie. A life estate per autre vie is a life estate measured by the life of someone other than the life tenant. Such an estate can be created directly by the grantor to A for the life of B. A's estate ends when B dies. It can also be created indirectly, as where the grantor conveys to B for life, and B later conveys interest to A. A owns an estate measured by B's life. It ends when B dies. Inheritability at common law: if A dies before B, the property was regarded as without an owner until B died. Today, statutes provide that such estates are divisible and inheritable if no special occupant is named in the original grant. A special occupant is a person named by the grantor to take the balance of the term, if any. Rights and duties of life tenant: doctrine of waste. There's like a lot written here. I'm just going to read the bold. It's saying, as a general rule, a life tenant may not consume or exploit natural resources on the property. Exceptions to this rule allow exploitation in the following circumstances in reasonable amounts where necessary for repair and maintenance of the land. When the life tenant is expressly given the right to exploit such resources in the grant, and when prior to the grant the land was used in exploitation. That's the one you get you on the MBE a lot. And you see this open minds doctrine being listed here. There's one more exception allowing exploitation, which is when the land is suitable only for such exploitation. There's a vague reasonableness limit on the amount of oil or coal a life tenant can remove from the property. So here's the open minds doctrine. If mining, extraction of minerals was done on the land before the life estate began, the life tenant may continue to mine the property, but is limited to the mines already open. Life tenant may not open any new mines. There is a trend away from this limitation, applying instead the rule 3 above to all natural resources, including minerals. Permissive waste and ameliorative waste. So permissive waste is absent a contrary provision in the instrument creating a life estate, a life tenant has a duty to make repairs to the property to keep it from being damaged by the weather and pay certain carrying charges like mortgage interest, property taxes, special assessments for public improvements. However, the duty is limited to the extent of the income or profits derived from the land, or if there is no actual income or profit, to the extent of reasonable rental value of the land. Failure to make required repairs or pay required carrying charges constitutes permissive waste. A future interest holder who expends funds in satisfaction of the life tenant's obligations is entitled to reimbursement. So you have obligation to repair, obligation to pay interest on encumbrances, obligation to pay taxes, special assessments for public improvements. So this one's reasonable as to the repairs. So the life tenant could place a mortgage on the life estate alone and would then be liable to for both principal and interest payments, right? So obligation to pay interest on encumbrances, and just so you know, the life tenant can mortgage their life estate. The obligation to pay taxes, life tenant is obligated to do that. And special assessments for public improvements. This is if it's shorter than the duration of the life estate, the life tenant is obligated to pay all the assessments. However, if the improvement is to outlast it, such as curbing sewers, water mains, a change in the grade of the street, taxes and assessments are apportioned equitably between the life tenant and the holders of the future interest. Apportionment of costs. Costs are usually apportioned by using a ratio produced by the market value of the life estate over market value of the property. No obligation to insure. I read that. I read the no liability for third-party torts, which is crazy. Ameliorative waste consists of acts economically benefiting the property. Occurs when the property is substantially changed, but the change increases the value of the property. At common law, any change to existing buildings or other improvements was always actionable waste, even if it improved the value of the property. Under modern authorities, however, a life tenant can substantially alter and even demolish existing buildings if 1, 2, 3, and 4 the market value of the future or other non-possessory interest is not diminished, and either the remainder do not object, or a substantial and permanent change in the neighborhood conditions has deprived the property of its current form of reasonable productivity or usefulness. And the example is like a shopping center, Black Acre, turned into a shabby apartment building. Doesn't seem to match any cases I've seen. Compare leasehold tenant. Leasehold tenants are treated differently than life tenants. Most leasehold tenants remain liable for ameliorative waste, even if the neighborhood has changed and the market value of the premises is increased. Compare worthless property. Under modern authority, a life tenant may ask for a judicial sale in a partition proceeding if it appears that the land is practically worthless in the present state. The proceeds are put in trust with income to the life tenant. That I feel like is a Poconos, Pennsylvania case or something. Renunciation of life estates. A life tenant who receives the estate by will or intestacy may renounce it. Perhaps this is the Poconos case. Because owning it would be burdensome if this occurs, the courts generally accelerate the future interest that follows a life estate, allowing it to become possessory immediately. Estate for years, periodic estates, estates at will, and tenancies at sufferance. I already read this. So we're on page 10. We're about to enter future interest in the next recording.